everyone. It is 3:30. We're going to get started. Let me double check my email to make sure no one's trying to get in. I don't see anyone. We will begin with bill introductions. Let's see. We'll do our guests today first. Representative Resman.
Thank you, Mr. Chairman. I'd like to introduce RS number 1022, which deals with the extension of search warrant, the amount of time it takes to execute a search warrant.
Any questions, committee? Representative Wheeler.
Who is sponsoring this, please?
Oh, I'm sorry, I am.
Okay, thank you.
Good question. Thank you.
I said aye.
Any objection? Do not see any. It will be introduced.
Thank you.
Thank you, sir. Head off the tax. Is that where you're headed? Somewhere. Representative Neely.
Thank you, Mr. Chairman. I'd like to introduce 21 RS 1019. This bill would require a 48-hour hold on violation of a PFA protection order.
Any questions? Any objection? It will be introduced. Anyone else on the committee? Okay, I have several here on behalf of, I guess, me and others. The first, it's the mute button, Representative Schreiber. RS 1026. That is our annual open records bill that we do every year for those that are sunsetting, and we need to consider whether or not we want to make those permanent. Let's see which other one's kind of on behalf of me. RS 1043. That's the closed case task force that we had a couple years ago. In corrections last year, we had an amendment brought by Representative Carmichael that would give the closed case task force some staff. This bill will not only give it some staff, but it will give an extension of time. Due to COVID and some other things, we didn't quite get our work done, and so that's what this one will do. Any questions on those two? Any objection? We will get those introduced. The other one, RS 0885, is on behalf of the Innocence Project, and this is the jailhouse witness bill that we heard last year. I believe it's almost exactly the same coming back this year. Any questions? Any objection? We will get that introduced as well. Anybody else? Not seeing any. We've got 3 bill hearings today, and hopefully we'll have some time to work bills, so let's get going. First bill opening the hearing on is House Bill 2125, and we will have Natalie let us know what it's about.
Thank you, Mr. Chairman. House Bill 2125 allows a copy of a will to be filed and admitted to probate. It also allows a will or a copy of a will filed within 6 months after the death of the testator to be admitted to probate at any time. So the bill amends KSA 59618A. Subsection A there is amended to provide that a copy of a decedent's will can be filed in the district court where the decedent last resided, along with that affidavit that's required in subsection B. And then subsection C is amended to provide that the will or a copy of the will within 6 months after the date of the testator, after the death of the testator, may be admitted to probate at any time after such filing, subject to any other applicable legal defenses to that admission. And I can take any questions.
Any questions for Natalie? Do not see any. We will begin our proponent testimony. He's not been with us for quite some time, but he used to spend some time in our committee. Tim O'Sullivan is here on behalf of the Bar Association. Can't quite hear you yet.
I'm okay now. Everybody hear me?
Yes, we can.
Okay, great. Mr. Chairman, members of the committee. I knew that when I had to testify today that we're going to have to follow social distancing. So I just didn't realize it's going to be 130 miles, I guess, away from you. But let me give you a little background on this bill, and then I'll tell you what it's designed to do, why it came into play. The current most of you know that to file a will, the rule is you have to file a petition to admit a will to probate within 6 months of date of death of the decedent, or it's void. So 59-618A is one exception where you can file and preserve the will and admit it later. And it requires certain things, of course. There's an affidavit you have to file with the will, giving names, addresses of heirs, legatees, that sort of thing, and you have to give them notice. But what the statute does not say is whether you can file a copy of a will. It just says file the will. If you've complied with all the affidavits, the question is that still a valid filing? I know that Johnson County was not taking them for a while. You couldn't do it with a copy. Now I understand they are taking them. And I know that they'll take them in Sedgwick County, but there's no express authorization of statute to file a copy. So the Kansas Bar Association felt its need to have that clarified so we can file a copy the same manner as a will. And what the amendments to the statute do, in addition to allowing a copy, it makes it clear that after you file a will and comply with the affidavit, that it can be admitted any time after you file it. You don't have to wait the 6 months, because it says if you file it, you admit it after 6 months. Well, it means you can go beyond 6 months, but it doesn't mean you can't file within the 6 months. This makes it clear that any time after filing, you can admit it to probate later. And also makes it clear that any other applicable legal defenses that you would have to admission of will to probate, for example, lack of competency, undue influence, inadequate witness attestation, would still be available when that will is being admitted to probate later. So those defenses are still applicable. One thing in our conceptual approval list in the KBA Legislative Committee and the Real Property Probate Trust section is that the affidavit should also state whether you're filing original or a copy. So anybody will notice that if they filed a copy, that those defenses to admitting a copy, which are, there's a presumption that the will was revoked when you file a copy. You have to rebut that presumption. Is still available when that will is admitted to probate. And that probably should be in subparagraph B of the bill, just before the current 5. There'd be a new 5 that would say that, but I'll leave that up to Joe Molina and a chairperson if in terms of how that, as a balloon payment or whatever, to put that in there. But it should basically, any affidavit that's filed after July 1st, 2021 needs to have that in the affidavit that you filed, that is either a copy or it's the original, one way or the other. Put everybody on notice if it's a copy. Now, most courts are keeping the originals, but not all of them in the past. We've had courts that send them back, the originals. We don't keep those. So it's very important to know whether it was original or a copy when it's submitted probate as to what defenses will be available. And so that would be the change I would suggest be made to the bill, House Bill 2125. But otherwise, I think it's a very good addition to our law to make it clear that a lot of people, you can't find the original. And we know that they probably didn't throw it away. They didn't revoke it. If you have a fully funded revocable trust and can't find the pour-over will to the trust, you can be pretty sure that it was lost. It was not destroyed so as to be revoked. That's what the bill is designed to do. I'll be glad to answer any questions anybody has.
Thank you. First question is from Representative Carmichael.
Thank you, Mr. Chairman. I do have questions for Mr. O'Sullivan, one of the finest lawyers in this area of the law in the entire state. But first, I need to ask my usual question of the reviser with the chair's leave. That is, have we seen this before?
Mr. Chairman, this is a new concept for this year, so this was not a reintroduction.
I thought maybe something had happened that I forgot. Okay. Mr. O'Sullivan, as I understand what you're telling us, all of the defenses to a copy of a will being admitted in lieu of the original are still going to be available here, except for the fact of that it can actually be filed. But as far as proving that it's the only copy, and it's been years since I remembered all those rules in law school. We're not changing anything else, are we? We're just saying you can file a copy?
Mr. Carmichael, that's correct. Every defense would be available had that copy been actually admitted to probate at that time, or still available.
Well, that sounds just like an excellent idea to me, Mr. O'Sullivan. Thank you.
Representative
Thank
Heiberger.
you.
Thank you, Mr. Chair, and thank you for being here. Is there not a separate procedure for admitting a copy of a will when the original can't be located? Am I remembering that wrong?
There is no separate procedure. It's just an available defense when you try to admit a will to probate. You have to basically assert in the petition reasons why the original will has not been revoked. And obviously that can be challenged. Inadequate evidence. Filed as a defense, and then it'd be the burden of proof would be on the petitioner to show by evidence that the will has not been revoked by preponderance of the evidence.
Very
Same
good. Any other questions? Okay, is there anyone else here as a proponent? Just Joe standing in the back of the room. I know you don't want to talk. I'm just calling you out. Are there any neutrals? Anyone as an opponent? Do not see any. We'll close the hearing on House Bill 2125. Open the hearing on House Bill 2098. And we'll have Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2098 would allow a court to change a spouse's name to a name other than a maiden name or former name during a divorce proceeding. So current law in KSA 232716 requires the court to order the restoration of a spouse's maiden name or former name at the request of that spouse during the course of a divorce proceeding. This bill would also allow the court to order a spouse's name be changed to a name that's different than that maiden name or former name at the request of the spouse. And I can take any questions.
Questions? Don't see any. We will begin with proponents, and we have Sarah Russ Martin.
Thank you, Chairman Patton, members of the committee. I'm Sarah Russ Martin, Legal and Policy Director at ks.gov, representing the 26 programs serving victims across the state. We are in support of House Bill 2098 because it will provide judges the discretion to change the names of a spouse as part of a divorce proceeding. At this point, I give you in my written testimony, I give you a far too common scenario there. For many domestic violence victims and stalking, in which stalking really becomes a part of the tactics that are used, the fear of further violence is very real, even after leaving the relationship. And so for some of them, to ensure their safety, they in fact do petition the court in a separate proceeding, aside from the divorce, to change their name. This separate action, to have that allowed as part of the divorce, or as this bill allows after the final decree, would allow someone to conduct the safety measure as part of sort of an ongoing safety plan that they may have, and do it with an existing court case. So we believe that this is an important step in allowing victims to seek safety, and we support the passage of House Bill 2098. I can stand for any questions at the appropriate time. Thank you.
Any questions, committee? Don't see any.
I thought I had my hand up. Maybe not. My hand not up?
Oh, it is. I scrolled down. Okay, Representative Carmichael and then Representative Heiberger. Nope.
I'll let Representative, I defer to my distinguished colleague from Lawrence, please.
I don't have a question. I just wanted to let you know there's another witness on, another proponent on WebEx.
I see she's appeared. Yes, thank you. Back to you.
And so am I now recognized. Thank you. Ms. Russ Martin, one of the things that this, as you pointed out, is that this legislation, even though a divorce decree has been granted, it allows apparently the proceeding to be reopened and a name changed to a later date. Is that correct?
That is correct.
And there's, as far as I can tell, there's no limitation on that. So if I was to have been divorced 25 years ago, and I want to change my name to Trout Fishing in America, and I just go reopen that old divorce and persuade the judge that that ought to be my name, and that's all I have to do?
Unless there are procedural limitations that would not allow that to happen within the court, there's nothing in the bill that I see that would not allow you to change your name to Trout Fishing.
Now, one of my concerns, though, is in listening to your testimony, part of the purpose of this is to help folks who've been the victims of a former spouse who's harassing, bothering, doing all the bad things that some former spouses do. But if we change the name in the divorce proceeding, doesn't the former spouse have access to that? I see a grin of recognition, so apparently there's a solution.
Well, I consulted some judges around that because in determining whether or not we were going to support this bill, honestly, and was told that if it is done after the final decree, then that notice does not have to be provided.
Well, I might disagree with those judges based upon my limited experience, because I think when you file a pleading in an action, whether it's open, closed, or otherwise, you have to provide notice to the parties and an opportunity to be heard. And I'm not sure we're accomplishing our purpose. You're muted.
Thank you, Representative Carmichael. If that is not the case, then that would influence whether or not we support this bill.
A second question along those same lines is, there's also claims of creditors and other folks when you file typically a change of name proceeding, and I haven't done that in many, many, many years, and always for legal services, but you publish notification in the newspaper that says, I'm John Carmichael, and now I want to be known as Trout Fishing in America, and that gives notice to my creditors to keep me from hiding assets. How are we going to protect the just claims of creditors if this is a confidential proceeding? Or maybe it's not. Maybe
No.
if there's still going to have to be noted, well, but there wouldn't have to be notice necessarily published if the change is in a divorce proceeding as opposed to a petition for change of name. I may be off here.
My understanding is that notice to creditors would still be that still must happen in order for the name change to occur.
I don't want to dig too deep into these weeds. Maybe we have another witness or another conferee that help us a little more with this. Thank you. I appreciate your help.
Thank you.
Other questions? Because we do have another conferee that I think can hopefully help us with these. Judge Picorni.
For inviting me. One, I've never done this before, so love having a new experience.
You are doing better than most people do, so way to go.
Oh, let me address Representative Carmichael's, or is it representative or senator? I don't want to get that wrong.
We call him.
Man, I have no desire to be a senator ever under any circumstance. Thank you.
I want to address your issue concerning notice. The Judicial Council on post-divorce actions has prepared a form that pro se litigants use all the time. There is no requirement that any notice be given. That form, the petition comes directly to me from the clerk's office. It's almost always filled out by hand. And the party has simply sworn that they were a party to the prior divorce, and they have now decided they wish to have a name change. And I sign that petition, and it's filed with the court, and that's I sign that order. I sign an order based on the petition, changing the name to whatever the request was. That's filed with the court. That becomes an official document. They can get a certified copy of that document and use it to change their name for purposes of Social Security, employment, driver's license. It's a valid document. I have I am absolutely unaware of any notice requirement. As far as notice to creditors, we don't send out notice to creditors in divorces because one of the parties has requested a name change. Solely based upon that request, the name change is granted. I had asked for this legislation based upon the narrowness of what I can do as a judge, in that it says the restoration of a maiden, which I find to be somewhat an anachronistic term these days, a maiden or former name. Now, we, in this day and age, we have a number of couples who they both have changed their names. They have a hyphenated name, they want to get rid of that hyphen. This goes both ways now with both spouses, the husband and the wife. But because of that restriction of a former or maiden name, I've had a number of interesting cases come before me where I think the parties are entitled to a name change or should get it in that divorce proceeding. But because of that restriction, I'm hesitant to do that. And one example was it was a pro se litigant, the wife, she said, yeah. I said, do you want a name change? She said, yes. So I said, you want your maiden name? And she said, well, no, not really. My dad sexually molested me, and I just don't ever think I want to have that name again, but I sure would like to take my mother's maiden name. Well, that wasn't her former name, and it wasn't her maiden name. So it doesn't fit into the statute, but I saw absolutely no harm. I didn't grant her request, but I didn't see any harm in her wanting to change her name to her mother's maiden name. Because that, once again, as a judge in a divorce, you have the domestic relations affidavit, you have their finances, you know what's going on there. I would have the discretion to say, based on your domestic relations affidavit, it looks like you might be trying to hide from creditors. That could be an issue that's raised, but I have not experienced that people consider a name change in a divorce to be a runaround to avoid detection or being bothered or harassed by creditors. And the same thing with even now, the law says you can come in 6 months later, a year later, 25 years later, and ask to be, trout fisher, whatever. I can't remember that. There's restriction on that time to come back in and change your name. And a number of, mainly mothers, after the children are out of their house, then they're thinking, yeah, there was a reason I kept my married name, because I was with all of us in the same household. But what's the point of keeping that name now? And so they'll want to come back in and change their name. Does that raise any questions from anybody or concerns? Anything I've said so far? I would also point out that we still have the common law, and in the common law, you did not have to go to court to change your name. By common law, which is still in effect, you just start using the name you want. The problem with that now is no official agency will accept that as your name. And I attribute most of it to 9/11. But I can't just start using a different name than what's on my passport and expect different countries to let me in. You need some kind of official piece of paper for most government agencies to grant that, for them to start using a different name for you. But the common law is still in effect. It's just a practicality that says you can't do it that way.
Okay, any questions? I see Representative Carmichael.
Thank you, Mr. Chairman. First, Your Honor, I apologize. I should not have used notice to creditors because that's from a completely different area of the law. I was thinking of in a petition to change name, the last time I did one, there was a requirement of publication so as to be notice to the public of this occurring. And I think you're telling me, though, within the sphere of divorce proceedings, there really isn't a functional equivalent of that. It's just part and parcel of the party's rights in a divorce.
That's correct. But your recollection is correct as far as if you are just doing the separate name change action, that actually it's discretionary with the judge, but generally, yes, you have to do notice by publication of your intent to change your name.
And I think, to correct my bad memory of the law, you actually, under the current law, have continuing jurisdiction to accomplish a name change even days, weeks, months, or years after the final decree of divorce.
That is correct. I mean, that's the current law.
And believe me, I don't practice in that area of the law, so I apologize for my errors. But what you don't apparently have the ability to do right now is to or arguably don't have the ability to do, is to restore a woman to any name other than her maiden name?
Maiden name or a former married name. Yes.
Okay.
Or
And by this change, if my spouse, who I'm not planning to divorce, our anniversary only yesterday, but if she wanted to change her name to her grandma's name of Jordan instead of her maiden name of Dumler, she could be a Jordan instead of a Dumler. Or I, as John Carmichael, I guess I could change my name to Dumler, so long as the court said that was okay.
That's correct.
Makes pretty good sense to me, Your Honor. And one final thing is the trout fishing in America reference came from an old case that my recollection was in Harvey County before Judge Sturm, where somebody wanted to change their name to Trout Fishing in America, and he didn't think that made good sense, and I don't recall what happened after that. Thank you very much.
Well, I was going to tell you that I was a spectator when somebody showed up for a name change and wanted the judge to change his name to Don Corleone. And the judge said no.
Well, I think there's some discretion there that we don't want to change names in a way that would cause confusion, misunderstanding, impersonation, and some other things in some old case somewhere. Thank you very much, Judge. Appreciate it.
Thank you.
Senator Keither.
Thank you, Mr. Chairman. I don't have a question. I just wanted to say hello.
Hello, Representative Keither. It's been a long time.
I know, and I just really wanted to say hi and appreciate your coming in to speak to us for this. This is great.
Well, once again, thanks for having me.
Yeah, good to see you.
Representative Heiberger.
Thank you, Mr. Chair. And I would just like to thank the judge for being here today. And I did introduce this on her behalf. We had a conversation about it. I just want to don't have any questions, but again, thank you for being here. I just want to make a couple of comments. I've actually had the same situation that the judge described occur, where the client did not want to have her maiden name, her birth name restored because of childhood abuse. And I actually asked for it in a petition in a different county, and the judge actually granted, but I did have to tell the client that I wasn't sure if it was going to work or not. And so this would make it more clear. And regarding representative trout fishing, there was actually a case in California in the early 90s where a young man, for his high school graduation present, requested a name change for trout fishing to Trout Fishing in America, and it was in fact granted. And last heard, he's teaching English in Japan.
Any other questions? Representative Carmichael, is your hand back up, or it's just remaining up?
I don't know if that's Freudian. It's not my intention. I'm having a little technical difficulty this afternoon. I apologize.
Got it. Okay. No worries. I'll take it down for you. Seeing no other
Permanently,
questions,
Mr. Chairman.
Is there anyone else here today as a proponent? Anyone here as a neutral? Any opponents? Don't see any. We're going to close the hearing on House Bill 2098. Thank you, everybody. Next, we will open the hearing on House Bill 2152. And back to Natalie.
Thank you, Mr. Chairman. House Bill 2152 clarifies how property held under a transfer on death deed is distributed when one beneficiary predeceases the grantor. So current law in KSA 593504 provides that if a grantee beneficiary dies prior to a record owner and an alternative grantee beneficiary has not been designated, then that transfer lapses. This bill would amend that section to provide that such a transfer will continue to lapse in the circumstance when the grantee beneficiary's interest in the transfer on death deed was not specifically made contingent on such grantee beneficiary surviving the owner. However, you'll see in C2 there, when a deceased grantee beneficiary leaves at least one then surviving issue upon death of the owner, when the interest would otherwise lapse under the rule described in paragraph 1 there, that interest would not lapse, and instead it would vest on the owner's death and the then surviving issue of the deceased grantee beneficiary on a per serves basis as the successor grantee. The bill also provides that judicial proceedings initiated to determine succession of ownership of real estate of a deceased record owner shall be subject to Chapter 59 of the Kansas Statutes Annotated to be used to determine dissent in those cases. And then the amendments made to this section would apply to deeds filed on or after July 1, 2014. And I can take any questions.
Any questions for Natalie? Natalie, since Representative Carmichael is permanently muted, we have not had this exact bill before, correct? But we've had the similar topic, was that 3 or 4 years ago, maybe?
I don't remember. This is not a reintroduction. You guys didn't have it last year. I don't remember right off the top of my head if there was a bill a couple years ago. Joe might remember that. Yeah, I'm glad you didn't ask me anything about per Sturpey's basis because I don't know.
Okay.
Mr. Chairman, there was a bill a few years ago. It was during Chairman Finch's tenure as the chair because we relied heavily on his expertise in the field. But I don't think it made it through, but I don't remember beyond that.
Okay, I couldn't remember what happened to it either. Okay, well, maybe our first proponent, Tim O'Sullivan, will be able to remind us what's happened with this over time. So, Tim, you're up.
Thank you, Chairman Patton. Yes, this was actually introduced in 2014 in a very similar bill. And the genesis of this was I was giving a program at Junction City, Kansas, about estate planning, a different topic. And after I got through talking, one of the attorneys came up and said that they had a situation in Dickinson County where there were 2 beneficiaries on a deed. It didn't say anything about survival. And one of them predeceased the owner. And the question was, what happened? And apparently there was a judge that gave an informal opinion. It apparently didn't get to the courts or appeal because it's not a record. That was just an informal opinion that when I'm reading it literally right out of the statute as it was. It says basically that when that occurs, basically the transfer lapses. The question is, what lapses? Just to that beneficiary or the whole thing? If you have one that predeceases. It's unclear, really, and I think that judge raised a good point, and the Real Property Probate Trust section looked at this in the Legislative Committee, and there's several possibilities, or at least a couple, that if one dies, does it go to the other beneficiary, remaining beneficiaries, or does the whole thing lapse that goes through probate? Well, obviously, that would distort if it went through probate necessarily what they intended, because probate could be completely different than those that got beneficiary deeds. Some clients might say, I'm not leaving anything to my children in the will because I've got TOD deeds going to them and they've already taken care of, so they've got a different disposition, maybe to a subsequent spouse. So it may go to, if it went through probate, not go the way they want it. So when we looked at this and looked at other states and what they did, the thought was that, first of all, that most of you are probably familiar with the anti-lapse statute, which says basically if you have a will that gives property to anyone within the 6th degree of relationship, and you've got to be far off to be beyond the 6th degree of relationship, most all of them are within 6th degree, that if unless the bequest is predicated on survival, if that beneficiary predeceases the testator, it goes to their issue. That's where it goes. It doesn't go to the other beneficiaries. And so that was one persuasive argument. The other one was that same thing with intestacy. If, for example, a child predeceases a parent and they die intestate and they have issue, their share is going to go to their descendants. If they have a spouse, half goes to spouse and half to descendants. But if they don't have a spouse, everything goes to descendants per stirpes. I kind of hate to use that word per stirpes with clients because they think it's a disease. And some of my dyslexic clients call it per stripes. So basically, it does. I think most of you lawyers in the group know what that means. If they survive, it goes to them. If not, if they leave surviving issue, it goes to their issue in the same amount. So the thought was, why wouldn't TOD deeds go the same way? So if they left a TOD beneficiary, the predeceased, most people, and they get these deeds off the internet, a lot of them don't even go to lawyers, but if they predeceased, most clients, if they went to a lawyer, would say they should go to their descendants, not to the other beneficiaries. They just don't even think about it. And I said that's what the anti-lapse statute was. Even if they go to a lawyer, if a lawyer doesn't say survival, it's going to go to their descendants on the anti-lapse statute if they're within the 6th degree. Well, this passed the House, but we had within the 6th degree, it goes to the Senate. It got over the Senate, and Joe Molina can correct me, but I think it got held up in the Senate because they thought that was too complicated, I guess, to go to the 6th degree and figure that out. So what we did was, on this resurrection of this bill this time, well, let's just make it simple, because I don't know if anybody's done a TOD deed to someone that's not within the 6th degree of relationship. But if they predeceased, it goes to their descendants. And that's what this bill does. But you'll note the effective date is for deeds filed after 2014. That's because it resurrected the bill. But the idea was after this effective date, so this statute should be effective if it passes for all wills, all deeds that are filed after July 1st of this year, not 2014. That's just a vestige from a prior bill. And I might mention one more thing, that in C1, it talks about unless the deed says it's not predicated on survival, it lapses. Well, if it predicates on survival, it always will lapse. If you don't survive, it goes to the other beneficiaries. And you can correct this. This is basically poor drafting in deeds. If you don't say survival, lawyers should say that. If they have a deed, if they want it to go to the other beneficiaries on TOD deed, all they have to say is, provided they survive. And if they don't, it's going to go to the other beneficiaries. This is a situation where they don't say whether they have to survive or not. So that survival provision that talks about in C1 really should be in C2, that it should always lapse if they predecease, if they don't have an alternate beneficiary, unless the deed says that they have to survive, in which case it would lapse, or it's going to someone who left a descendant still living, issue still living, in which case it should go per stirpes to those beneficiaries of the deceased beneficiary. So that's what it's designed to do. It'll take a little amendment, it looks like, the C1 to make the intent carried out to that one provision about, and I think that Joe and Mr. Chairman, you could work out a balloon amendment to switch basically that clause that's in C1 down to C2, that it will only apply, it will always lapse if the beneficiary predeceases, if they don't leave an alternate beneficiary, unless the beneficiary is predicated on survival. Then it would always lapse there anyway. The only exception would be, it doesn't say whether they survive or not, and they leave surviving issue, it goes their issue. And the idea is Chapter 59 to be like a determination of descent proceeding. You'd file a petition just like a determination of descent where they die intestate, and here are the beneficiaries, get that court approved, so you don't have any problems with who inherits this property. And I might tell you, in all fairness, there's an argument out there, why shouldn't it go to the other beneficiaries? Well, I've been out in practice a long time, 45 years, and I would tell you well over 90% of the clients are going to want to go to the descendants, which is why you have that provision in the anti-lapse statute, why you have an intestacy. It's designed to do what most people would want if that beneficiary predeceased leaving surviving issue. And that's what this TOD deed is designed to do, is do just exactly that. And I'm open for any questions about this.
Good. I appreciate you clarifying the 2014 date. When I read this earlier, I'm like, where does that date come from? It made no sense to me, and I see we just need to get it fixed. We'll get with Joe. Other questions,
Okay.
committee? I don't see any at all. You did such a great job. Okay. Anyone else here as a proponent? Anyone as a neutral? Is there anyone as an opponent? Seeing none of those, we'll close this hearing on House Bill 2152. Committee, pull up. We're just going to work through these in numerical order. The first one is 2001. We will start off on all these by having Natalie remind us what the bill is about.
Thanks, Mr. Chairman. House Bill 2001 creates the crime of sexual extortion and also requires an offender who was found guilty of committing this crime to register under the Offender Registration Act for 15 years when one of the parties involved is less than 18. And I can take any questions.
Any questions for Natalie? See any? Are there amendments? Representative Owens.
Thank you, Mr. Chairman. I actually have two amendments to this bill. So we will start with the first one. We could send that one out regarding some of the elements of the bill. And while that's being distributed, I'll talk about that a little bit. It just changes the language just slightly to broaden things just a little bit. It'll be coming momentarily and might be a little bit easier. Instead of using the words such in paragraph 1 and 2, it is any. And it also broadens it to say or other recording in lieu of let's see, a threat to injure the property or reputation of a person, commit violence against a person, or distribute an image or video. It says or other recording. So a couple of technicalities there. There you go. I don't know if you guys can see that or if you have it in your inbox yet. So as I mentioned, adds other recordings and says with the intent to occur instead of such person, any person. So just a little bit of clarification that was sought on this one to make sure that we get the full intent of it.
Okay, why don't we have you move your motion, your amendment?
Thank you. I move my amendment.
Is there a second? Representative Neely? Any discussion on this amendment? Representative Carmichael.
Thank you. This would be a question either for the maker of the amendment or for our reviser. I understand the change that we're making there at the first paragraph of section 1. But in subparagraphs 1 and 2, the substitution of any for such actually does, I believe, have a significant substantive difference. And if I'm understanding this, under the language as originally drafted, the communication had to be to the person who was going to be coerced. Now there could be a communication about the reputation of my mother designed to coerce me if I were of the appropriate age groups. Is that what we're doing here?
And I can take a shot, but Natalie, if you want to explain the technical applications, that might be good.
Mr. Chairman, I do think that would be the effect of the change described here.
And so then if I might follow up, and I'm sorry, I just haven't had a chance to wrap my head around this, but it would seem then that both of the victims, the person who the information is being released about and the person being coerced, do they both have to be underage, or can one of them be in their 50s?
Mr. Chairman, are you talking about the registration piece?
I'm talking about the two changes from such to any.
So the 18-year-old requirement is just related to whether the person would have to register under the Offender Registration Act.
Already jump into
So-
my second amendment, Representative Carmichael.
And so if, say you did have that situation you described where you have three people, you have the person that you are, communicating a threat to injure the property or reputation, but it's with the intent to coerce someone else, into sending you a picture or getting a picture from someone else. If any of those parties involved were under 18, then that would trigger the registration requirement.
So if I, at the age of 63, release information about someone who is 60 designed to coerce a 16-year-old to do something, that would require registration. But conversely, if I were to release information about a 16-year-old designed to coerce a 64-year-old to take some action, would that also require registration?
I think if any of the parties involved were less than 18.
Okay, so this is a very different bill than what the proponents testified about. And I have concern about changing this on the fly without due consideration and deliberation. Thank you, Mr. Chairman.
Representative Ralph.
Representative, the maker of the amendment, is the purpose of the amendment to expand who might be covered on this? Let's take the age brackets out of it and just say if this is I threaten to disclose information from one person about a friend of theirs so that we kind of have three people involved. Is the intent of this to broaden that, to make sure it's not just I'm threatening you, but I'm threatening you about disclosing something to another third party? Is that the general intent?
That's exactly what I'm after. The idea that a threat to injure a family member and not just the victim, for example. That's all that we're trying to make sure that we cover in this, is making sure that that the third party, if there's a threat to injure a third party, that we're covering that in this.
Appreciate
That's
it.
what I'm after.
That's the clarity I was looking for. Thank you, Mr. Chair.
Representative Jennings.
Perhaps a question for Natalie. So this relates particularly has a sexual context to it. But to convey a threat to an individual to injure them particularly, do we not have a law that generally covers that would be called criminal threat, that would apply to anyone regardless of age or the character of the threat that's being made?
Mr. Chairman, there are a few different crimes that would also cover similar conduct here. So criminal threat would be one of them. Breach of privacy, specifically with the distribution of like images or recordings of people, that is covered there. And then, we do have just like the regular extortion crime. So, I mean, this one is specific to these, to this sexual type of behavior, but.
Other questions? I think he's just left his hand up. Representative Carmichael, do you have another question?
I apologize. No, I'm trying to read the balloon amendment and it covers up my screen on WebEx.
No worries.
I apologize.
Representative Humphreys.
Oh, thank you, Mr. Chairman. Could the maker of the amendment remind me why we have this? I mean, who brought this bill? I don't have my computer in front of me, so I don't have all the details. So remind me about this bill.
Sure. So this bill has been introduced over I think the second or the third year in a row that we've worked this bill. I have worked with the group from John Monroe with 1861 Consulting and his pro bono clients who have worked to pass this legislation in various other states. I believe it's passed in 27 or 28 states because it specifically tailors extortion of a sexual nature, the distribution or the threat to distribute inappropriate pictures, and as such extort things as a result of that.
Okay, all right, thank you. Mr. Chairman.
Representative Carmichael.
Thank you, Mr. Chair. I believe the rule requires that when a bill is offered, that the real party in interest, if you will, has to be disclosed. I had understood that this was the representative's bill introduction, and now he tells it is on behalf of the client of a lobbyist. So I think our records and our minutes should reflect at whose request was this bill introduced.
This bill was not requested in our committee, Representative Carmichael. It was pre-filed, so it would not be reflected in our minutes.
Oh, okay. Okay. So it would not be subject to the rule at all. This is Representative Owens' bill, I believe.
Correct.
I need to brief it for my caucus. I want to make sure I do it correctly.
That's
So he's amending his bill to do something different than what he did in his pre-filed bill. I appreciate the distinction.
That is correct. Representative
Okay.
Jennings?
Yeah, maybe to just help you move things along here a little bit, I'd like to second the motion to amend, but I want to divide the question to two questions. One being the words any, those clustered together as one, and other recording as the second part of that.
Whatever the will of the committee is, Mr. Chairman.
Okay, I see lots of nodding, so let's do that, Natalie. We actually we had a second already. No, that's okay. That's okay. So to divide the question, do I need a second to do that, Natalie?
Mr. Chairman, you already had a second on the motion, so as long as the maker of the motion and the second consent to that, then I think that'd be fine.
I think they both. Yes, Representative Owens?
I'm consensual, yes.
And Representative Neely. Okay, so let's do the or recording part first. Any further discussion on that? Representative Hoheisel.
Thank you, Mr. Chair. Under which amendment or which vote will a comma go?
The comma is in this amendment. Let me look online and make sure. I don't see any other questions. So Representative Owens, you can close on your first part.
I close.
Heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. Now we're back on to the second part of this first amendment, which adds the two innies, one in line 11 and one in line 16. Any further discussion on that? Not seeing any. Representative Owens?
Well, I do recognize the conversation that's occurred, and I think it is important to point out, like I said, the intent of this is to make sure that close family members and friends are protected as well, while somebody else is trying to sexually extort somebody. So I would still encourage passage and move my motion.
For the motion, all in favor say aye.
Aye.
All opposed say no. Motion appears to fail. Division's been called. All in favor, please raise your hand. Okay. All opposed, raise your hand. Okay, so it appears to have 3 yes votes. No, yes, 3 yes votes and 10 no votes. Something close to that. Certainly still fails. Motion fails.
Close enough.
Okay, we are back on the bill, and Representative Owens, you have a second amendment.
First one went so swimmingly well, we'll try this a second time. One of the concerns that was brought up as a result of this bill was the concern of having minors have to register for the period and be registered as a sexual offender. So what this bill does, hopefully, is calm that concern and basically says if you have been adjudicated as a juvenile from the court's perspective, then you would not have to register. And Oh, I guess I should have encouraged that to be distributed. So hopefully that's in process.
I'm not seeing it in my email yet, but I'm sure it's on its way. Okay, questions, or do we want Natalie to explain it? Anyone? Representative Hoheisel.
Thank you, Mr. Chair. This question is for the advisor. Natalie, do we have this language in any other sex crimes that involve juveniles?
Mr. Chairman, you'll see where this language is inserted. If you start at page 6, subsection T1, what this section of law is the definition section for the Kansas Offender Registration Act. And so we provide here that, notwithstanding any other provision of this section, offender doesn't include any of the following people. So you'll see that right now, anyone convicted of unlawful transmission of a visual depiction of a child, or aggravated unlawful transmission of a visual depiction of a child. Also a juvenile who would be adjudicated for one of those crimes. Those two are excluded from registration. And so this would just add that to the list, that if you were adjudicated as a juvenile offender for sexual extortion, then you would not be registerable. So not exactly a sex offense necessarily, but unlawful transmission of a visual depiction of a child.
Thank you. Thank you for that, Natalie. Thank you, Mr. Chair.
Representative Carmichael? Oh, the darn hand keeps staying up. Sorry. There we go. Hands down.
I thought we made a motion to permanently mute.
We did. Motion was, yeah. Look at it's back up again. Because I took it down, so then he raised it back up. There we go. Quit
You
touching
don't
it,
want to make me come down there.
Okay, I don't see any other hands online or in person, so Representative, we need a motion.
Oh, yeah. So I make said motion.
And a second by Representative Hoheisel. Any discussion on this third amendment? Do not see any. Representative Owens, you may close.
I close.
You've heard the motion. All in favor say aye. All opposed say no. Motion carries. Are there further amendments on House Bill 2001? Do not see any. What's the pleasure of the committee? Representative Owens?
Thank you, Mr. Chairman. I recommend that we pass out House Bill 2001 favorably for passage.
As amended.
As amended.
Is there a second? Representative Hoheisel, seconds. Any discussion? Representative Hoheisel?
Thank you, Mr. Chair. This question is for the maker of the motion. Is this bill retroactive? Never mind. I withdraw my motion, Mr. Chair, or my
Your question?
question. Thank you.
You're still good with the second? Okay. Any other questions? Do not see any. Representative Owens?
I close.
Heard the motion. All in favor say aye. All opposed say no. Motion carries. And Kathy, who is not here but is listening in, those that want their affirmative votes recorded, Representative Owens, Representative Hoheisel, Representative Carmichael, Representative O'Hobbesam, and Representative Heiberger, and Representative Neely. We added a new one. Okay. Let's see. Now let's move on to House Bill 2075. Natalie?
Mr. Chairman, House Bill 2075 would allow venue for an adoption in the case when the state is the agency, to be where the state agency or any subcontracting agency has an office.
Any questions for Natalie? Don't see any. Any amendments? Don't see those either. And for a motion on the bill, Representative Humphries.
Mr. Chairman, I move that the committee reports House Bill, I don't have it written down,
2075.
2075 favorably for passage.
With a second by Representative Jennings. Any discussion? Do not see any. Representative Humphries?
I close.
Heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. Kathy, those wanting their affirmative votes recorded. Owens, Hoheisel, Humphries, Carmichael, O'Hobson. Okay. Let's move on to 2096. And Natalie.
Mr. Chairman, House Bill 2096 would authorize Department of Corrections employees, local corrections or detention officers, judicial branch employees, municipal court employees, and administrative hearing officers to have identifying information restricted from public access on public websites that identify either their home address or home ownership information.
Any questions for Natalie? Are there any amendments? What is the pleasure of the committee? Representative Heiberger?
I was engaged. Could you refresh me on the bill number?
2096.
Thank you.
Guessing that was not a motion. Is there a motion concerning this bill?
Mr. Chairman,
Yes, Representative Keither.
I'll make said motion.
Thank you. Is there a second? Representative Jennings? Any discussion? Okay, Representative Keither, you may close.
I close.
For the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. Those wanting their affirmative votes recorded are Representative Owens, Representative Hoheisel, Representative Heiberger, Representative Neely, Representative Carmichael, and Representative O'Hobson. I don't believe there were any no votes. Okay. Next one, 2109.
Thanks,
Natalie?
Mr. Chairman. House Bill 2109 increases the county population threshold for a county to be required to have a lawyer representative on the Board of Indigent Defense Services. It also increases the number of lawyer members and decreases the number of non-lawyer members on the board.
Any questions? Any amendments? You'll recall this is a bill we passed out last year, passed the floor, and then it didn't make it any further. Any amendments? No? Is there a motion concerning the bill? Representative Hoheisel?
Thank you, Mr. Chair. I move that we pass out HB 2109 favorably.
Is there a second? Representative Shriver? Okay, it's a fun time in the committee room, guys. You at home.
Pretty jovial bunch today.
Any discussion? Not seeing any. Representative Hoheisel?
Close.
Heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. Kathy, the votes that we would like to see recorded: Representative Owens, Hoheisel, Heiberger, Carmichael, O'Hobson. And unless Natalie tells me I'm skipping one, the last one for today is 2120.
Matches my notes.
Okay, perfect. And Natalie, would you let us know what this one is?
Yes, Mr. Chairman, House Bill 2120 removes the spousal exception from the crime of sexual battery.
Any questions for Natalie? This is another repeat, actually a third time repeat. Any amendments? Is there a motion concerning the bill? Representative Hoheisel.
Thank you, Mr. Chair. I move that we pass out HB 2120 favorably.
For a second, Representative Schreiber. The third by Representative Keither. Any discussion? Not see any. Representative Hoheisel, back to you.
Close.
For the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. The affirmative votes, Kathy. Owens, Hoheisel, Heiberger, Neely, Carmichael, and O'Hobison. Good work, committee. We're even done early. Thank you all.
Mr. Chairman,
yes,
could I be recognized?
you can.
Mr. Chairman, just on a matter of personal privilege, Representative Heiberger reminded me correctly that the case of trout fishing in America was in a case book at the University of Kansas School of Law, many years ago. The case that I was thinking of in front of Judge Sturm in Harvey County involved a request to change the name to Mickey Mouse. So I stand corrected. My appreciation to Representative Heiberger.
Thank you for pointing that out. Okay, committee, there was a revised agenda that went out a little bit ago. It adds, we only had one bill on the first agenda. We're now starting to fill out next week, and we will have another revision that comes out first thing in the morning. So we should have a couple bills Monday, a couple bills Tuesday, I think one on Wednesday, and then unless something changes, we'll probably spend Thursday just working bills, but we'll see. So,
All right.
thanks, everybody. We're adjourned. We'll see you, if you're not here first thing in the morning.
Mr. Chairman, can I say something real quick?
Go Chiefs, yes.
Point of personal privilege. I know we're meeting, next meeting is going to be on Monday. I know this weekend is going to be a big weekend for Kansas City Chiefs fans, so go Chiefs. That's all I can say.
Very good. Hopefully it's a happy Monday.
Yes. Yay.
See y'all later.
All right. Thank you.